Maritime labor contracts carry inherent physical risks. A seafarer operates inside a heavy industrial environment that is continuously exposed to unpredictable elements. The Supreme Court case of ARGUILLES v. Wilhelmsen Smith-Bell Manning centers on a seafarer who tore his Achilles tendon during an off-duty basketball game with his colleagues. The employer immediately denied the worker's claim for disability benefits. Their defense relied on a simple premise: playing a leisure sport is not a work-related duty, and an injury sustained while off the clock is not the company's responsibility. The Philippine Supreme Court rejected that argument. They reversed the lower tribunals and awarded the seafarer the maximum allowable compensation of $90,000 for total and permanent disability. A recreational injury sustained during leisure time legally triggered the same maximum payout as a catastrophic occupational hazard. The Manning Agency lost this case because their legal strategy failed on two distinct fronts. First, they misunderstood the substantive boundaries of maritime employment. Second, they committed procedural errors regarding the statutory timelines required for medical assessments. The court's decision illustrates how the traditional off-duty defense can be neutralized by specific legal doctrines governing the maritime workspace. Furthermore, if an employer defaults on the strict procedure for maritime human resources and legal practitioners, surviving a labor dispute depends on a precise understanding of both the physical definitions of work and the rigid schedules of statutory recovery. We have to establish the unique reality of maritime billeting. Unlike shoreside employees, a seafarer's workplace and living quarters are the exact same physical location. This schematic of a standard cargo ship provides our base model. The POEA Standard Employment Contract defines a compensable injury as one arising out of and in the course of employment. Employers often interpret course of employment strictly. They argue liability only exists when the crew member is actively working in a high-risk zone, like the engine room or the navigational bridge. But jurisprudence applies the Bunkhouse Rule. This expands the legal zone of employment to include the sleeping quarters and mess halls. The logic is exact. When a contract mandates that a worker live on premises furnished by the employer, the obligation to be there creates the risk of injury, regardless of the hour. We then apply the Personal Comfort Doctrine. Now the zone of risk encompasses the entire vessel, including recreational spaces and exterior decks. Under this doctrine, acts necessary to a worker's health and rest better enable them to perform their jobs and are considered incidental to their service. These domestic doctrines align with international maritime standards, specifically International Labor Organization Recommendation No. 138. ILO Recommendation 138 explicitly mandates that healthy recreation, such as gymnastics and sports, must be provided and encouraged on board by the shipowner. Playing basketball on a cargo ship is a legally mandated activity for crew welfare. Because it indirectly benefits the shipowner, the off-duty defense is effectively nullified. Once an injury occurs during the contract term inside this expanded zone of employment, the evidentiary burden shifts to the employer. This flowchart illustrates the singular exception found in POEA Sec. Section 20D. An employer can only deny the claim if the injury resulted from a willful, criminal, or intentional breach of duties. To trigger a denial, the employer must affirmatively prove notorious negligence. Notorious negligence requires a deliberate, reckless disregard for personal safety. A simple accident does not meet this threshold. When we apply this standard to an employer-sanctioned game of basketball, the defense fails. The Supreme Court found no inherent danger in participating in normal shipboard sports. The seafarer did not intentionally self-harm, he simply lost his balance. Unless a Manning Agency produces hard evidence of intentional harm or severe recklessness, an injury sustained during shipboard recreation remains fully compensable. Establishing that an Achilles tear is compensable is only the first step. A torn tendon is a partial injury. We must examine how it resulted in the maximum payout of $90,000. This timeline tracks the procedural framework governing maritime medical recovery, starting from the day of medical repatriation. Supreme Court jurisprudence, specifically the Elberg Ship Management Guideposts, mandates an absolute requirement. The company-designated physician must issue a definitive, final grading of the seafarer's disability within exactly 120 days of repatriation. The only exception is if the physician provides sufficient medical justification for continued treatment, which extends the window to a cap of 240 days. In ARGUILLES, the employer provided physical therapy. However, they failed to issue the required final medical assessment before either the 120-day or the 240-day deadlines expired. The employer attempted to resolve this omission during the appeal process before the National Labor Relations Commission. Their late evidence was a medical prescription pad with the words "fit to work" scribbled on it. The Supreme Court rejected this document. They ruled it a mere scrap of paper, lacking the substance and formal authority of a final medical report. Missing the 120 or 240-day window without issuing a valid assessment carries an automatic legal penalty. It triggers disability by operation of law. Procedural negligence strips the employer of their right to contest the medical reality. The law legally fictionalizes the injury into a total and permanent disability, regardless of whether the worker's ankle had actually healed. The enforcement of this $90,000 judgment, plus 6% annual interest, carries direct implications for corporate leadership. This chart outlines the liability structure defined by Section 10 of the Migrant Workers Act. The statute imposes joint and several, or solidary, liability across these parties for all maritime money claims. This provision effectively pierces the corporate veil. It makes the executives of the manning agency personally and collectively liable for paying the judgment alongside the corporation. Operational misunderstandings aboard the vessel, combined with documentation failures in the office, directly translate into financial exposure for corporate officers. Defending against maritime labor claims requires precision in both substantive legal boundaries and procedural execution. Spatially, the legal workplace is the entire footprint of the vessel. The Bunkhouse Rule and the Personal Comfort Doctrine erase the distinction between workstations and living quarters. Temporally, statutory medical deadlines are unforgiving. Informal documentation and late assessments are legally worthless. Legal and crewing professionals must treat onboard injuries as work-related by default. They must audit their medical timelines and ensure formal assessments are issued within the first 120 days. Misunderstanding the scope of employment creates the initial exposure, but it is the procedural defaults that guarantee the maximum legal penalty.